Hello, everyone, and welcome to the Legal 500 webinar titled Tax Compliance, Addressing the Ongoing Challenge of Entity Compliance and Governance. I want to thank everyone joining us today, as well as the sponsor for the event, Diligent, for helping to organize the webinar. Regulations around the world are getting tough on tax. Led by the Organization for Economic Cooperation, OECD, and its Base Erosion and Profit Shifting, BEPS project, it is getting increasingly complex and burdensome for companies to ensure that all their legal entities comply with local company and tax laws. The repercussions of not complying can result in hefty financial penalties compromising your organization's financial statement and compliance with business operations such as M&A and obtaining funding. We're joined by two panelists today to address tax compliance. The first is Tim Sarson, Value Change Management Partner and UK Head of Tax Policy at KPMG. Tim acts for KPMG's spokesperson in the print and broadcast media and primary contact for government on tax policy matters. He has worked in the field of international tax for 25 years, specializing in value chain management, the design and implementation of cross-border operating models for multinationals across a range of sectors. We're also joined by James Anderson, Head of European Tax at Skadden Arps. James regularly advises on controversy matters in the field of state aid, inter-party tax-related disputes, and tax authority litigation. His commercial background is the establishment and ongoing operations of various alternative and traditional asset management structures, as well as other private capital arrangements and compensation for fund principals. He also has experience in a full range of public capital markets transactions, and more recently, his practice has focused on new intersections between private capital and various technologies such as AI, insurance, blockchain, and renewable energy. Notably, he helped set up and now co-runs the Skadden Foundation in the UK. It's called JUST, or Justice First Skadden Trainee, whereby they put young graduates into trainee positions and fund their costs before they qualify as a social welfare focused advocate working in Scotland or England and Wales. So before we properly begin, I'd also like to let you know that we'll be running a series of polls during our conversation today regarding tax compliance. We'd like to learn more about the experiences of attendees, so I highly recommend answering the questions now. When we reach the halfway point, we'll show the results of the poll and get the responses from our panelists. Additionally, we have a Q&A set up for you to ask your panelists any questions, and we'll set aside some time at the end of the webinar to answer them. We will aim to answer as many as we can. So thank you. And with Tim and James, welcome. Really appreciate both of you taking the time to speak with us today. So my first question, this is going to be for both of you. It's just a sort of a general overview, understanding your both experiences, namely as what you think are the main tax compliance trends that you both saw in 2022, sort of the issues that came up most frequently when you talk to industry professionals and GCs, and what do you expect in the near future? Either of you can go first.
Shall I kick off? I'd say it was probably a mixture of, so there are a number of trends which are long-term trends. So they've been running for years and years, and there's continuation of those. And one of the big ones there is, I think, a convergence globally in terms of the attitude of tax professionals and of multinationals towards substance versus form. So something which started in Europe a decade or so ago and was seen through the BEPS project, that the focus on what is actually happening in your business and reflecting that from a tax compliance perspective. I think the Americans are kind of on board much more with that these days. The other one was a couple of quite specific trends this year. First of all, a lot of concern about how to properly manage exit from Russia and Belarus following the Russian invasion of Ukraine, as you can imagine. And an unwinding of a lot of the compliance issues that came about as a result of COVID, when people were often stuck in the wrong country. So we're sort of back to normality, or something close to normality this year.
Thanks, Tim. Thanks, Nathan, for the introduction, and apologies, I'm using a wired device, which looks like I'm about 15 years out of date. But I am in a very busy location at Westminster County Hall, so this is why I've reverted to black cable. I hope you can hear me okay. So I would summarize the three trends in 22 and probably 21 as well as, first of all, information, secondly, collection and maintenance, and thirdly, improvement of discipline. So in terms of information, I think the big stress point for corporates is finding out what's going on within their organizations, which are relevant to the tax compliance function. And that's not as easy as it sounds. And I think we're going to talk about that a bit more later. The second is, what do you do with that data? You know, how do you preserve it? Is it relevant? Should it be kept or destroyed? And we're going to talk about that a bit more. But data management is very important. And the third point was discipline. I've seen a massive increase in the focus on discipline, and I mean that in a sense of privilege, legal privilege, GDPR. How do we keep data ready for any revenue inquiries if they come in? There's a general rigor that's been introduced, I think, into the corporate space from a compliance perspective, which I think the actual pandemic rigors actually reinforced, just because data and people and documents were scattered all over the earth. I think there was a sense of mild panic.
Okay, I really appreciate both of you answering questions. You both have slightly different viewpoints on this. I think next question I have is for Tim. You mentioned BEPS, and so I'm wondering if you could speak a little bit more about the legislative and regulatory compliance expectations up to this point, and the effect of BEPS, and how are they likely to do so going forward?
Sure. So we've had 2 rounds of BEPS now. BEPS, well, the original BEPS and then the sequel, BEPS 2.0, and we're in the middle of BEPS 2.0 at the moment. I'll come on to that a little bit later. Just as a reminder, the whole BEPS project came about as a result of a sense of unhappiness amongst tax regimes, particularly in the large developed markets, that there were multinationals who appeared to be essentially putting profitable activities in low tax locations with impunity, and therefore diverting profits away from where those tax authorities believed they belonged. The two BEPS rounds have been quite different, but I think the way that they've affected taxpayer behaviour has been quite consistent. So in the first round, which was in the middle of the last decade, essentially, what the real focus there was, I mean, there were several actions, there were 15 actions, but the real focus there was about giving tax authorities and member states greater visibility and transparency over what multinationals were doing, and also encouraging multinationals to undertake tax planning, if that's the right term, that was in line with the substance of how the business actually operates. So it was intended to be essentially the end of letterbox companies, the end of brass plaques, the end of putting billions of value in tax havens, for example, without much substance behind them. Now, I think the behavioural change that triggered has been absolutely fundamental. It's completely rewritten the way that tax worked, particularly for European-based multinationals. I would say that North America or the US was a little bit later to the party, but they're getting there. So it's quite rare these days to see taxpayers looking to establish arrangements that are not based on, at least at some level, where and how they actually create value and do things internationally. The second round of BEPS, and I guess we'll probably get into some of this in a bit more detail later, but just as a summary, that there are 2 pillars. There's pillar 1, which is a sort of follow-up to the first BEPS, and it's really about shuffling around taxable profit from countries where historically the transfer pricing model has put that profit, so from headquarter type locations to the big consumer markets. That one's still up in the air a bit, but the really important one is pillar 2, which has established this 15%, or is looking to establish this 15% minimum global tax rate. And that has definitely already had a big behavioural impact. Most of the clients I work with just work on the assumption that the lowest tax rate that they will be paying anywhere, certainly if they're large companies, will be 15%, and that's affected their location choices already.
I think maybe following on that, I was actually going to ask James about this, so it's, I think, a great segue. James, I'm wondering, what major changes have you seen in your own industry so far relating to global trends on the global minimum tax rate? And what main trends do you see with regard to corporate tax laws, And how do you see these impacting major financial institutions in the UK and Ireland?
Okay, so that's about a 25-minute answer, Nathan, but I'm not going to give it to you because it's going to destroy the timetable. I think there are no global trends on the minimum tax rate yet because we're all holding our breath. There's clearly, from a national legislative perspective, at least two countries, the UK and the Netherlands, from the sort of developed nations that have rushed into drafting a lot of the necessary legislation, but the rest of the world, I think, is holding back a little just to see if the global deal does actually stack up this year. So I wouldn't say we're in trends territory. One of the big trends in an M&A context, not compliance necessarily, but it's certainly going to touch the desks of heads of tax from the minimum tax perspective, is just how to model for acquisitions and integration post-acquisition. We've seen already financial institutions who are advising on deals and the corporates doing the deals struggling a little bit about what effective tax rate to put into their acquired target and the post-acquisition integration, because clearly the model changes depending on whether the various countries where that target operates has introduced a minimum tax. What provisions do you need to put into the documentation to deal with the changes in the structure, which could lead to a change in the application of the minimum tax in that jurisdiction, because it's all related to an overall group ETR. So that's really the first sign of a trend, but I think I'm not seeing yet anyway, other than hiring lots of people, people really rushing into restructuring yet for global minimum tax. I do think, though, there is another thing just to flag up, that we're going to come on to this maybe in more detail, but I think heads of tax and advisors are expecting non-compliance. There's going to be an impossibility to comply within the first few years of everything that's going on with Pillar 2 if it does get in. So it's about getting your defences in ready, looking at, as I said earlier, the data you can collect to show why you may not have caught a need for a top-up tax in your filings. Dealing with local authorities is going to be tough if they're still going up the curve on the statute, and you can expect technical non-compliance in that sense. So I think that's the biggest area of concern for our clients on Pillar 2, which is just, it's going to take 3 to 5 years to bed in, and one should expect non-compliance during that time.
Okay, thanks so much for that, James. Tim, I have one question for you. We sort of talked about this beforehand, which was that one major change that's occurred in the tax compliance space over so many years has been an increase in the accumulation of data and automation. And so this holds well when considering this best practices, namely data and automation are key to reasonable defenses for a company facing any issues with compliance. So would you mind telling me a little bit more about the role of risk mitigation within tax compliance and the difficulties you face with increased data automation?
Yeah, I think there are two streams to talk about here, because one is much more well advanced and well embedded in tax systems than the other, and actually it's the second one that's causing quite a lot of trouble that James actually alluded to just now around the sort of non-compliance. In indirect taxes, which are transactional based taxes, there has been a constant ramping up over the last decade or more, particularly in certain tax regimes. I think Brazil was a front runner, but the UK has been looking to do it through their Making Tax Digital program. A number of other countries around Europe have been automating or looking for automated data and real-time data provision associated with things like VAT filings. Now, the difficulty with that kind of data in terms of risk mitigation is it's not something that you can really kind of put together after the event. You've got to have the right data coming out of your initial transactional systems, and if there are errors there, then you're immediately non-compliant. So if you've got an error in your invoicing process or in the customer data that you're pulling through in terms of the VAT. The VAT treatment of the customer of the transaction, then you're immediately non-compliant, and there can be penalties from day one. But the good thing is that a lot of ERP systems, a lot of internal systems are set up to get transactional data correct. The difference with corporate tax, both corporate tax filings and things like transfer pricing, is that they've tended to be after the event, and the general gist was, so long as your financial data and the more qualitative data and information to support that was in place when you filed your tax return after the event and looked correct then. It didn't really matter what happened from day 1 to day 365. It was about what the final outcome looked like. But that's under threat now. Not only do we have much quicker turnaround times that have been introduced for things like TP documentation and supporting intercompany transaction schedules that a number of countries, I think Australia is probably the most extreme version, require to support that. But we've also got Pillar 2 coming and Pillar 1 potentially, and the data requirements for Pillar 2 are very different from what was needed for country by country reporting, where there was a degree to which you could sort of fudge the numbers, so long as they were giving an overall sort of view materially of what the right answer was. There are new data sources that will be needed to support Pillar 2 filing, where you're actually paying tax, you're paying top-up tax on a specific amount. There's no materiality threshold there. And I think the most company systems are not set up to generate data in the right way. Alongside this, and I guess James might talk about this too, there's a whole layer of data privacy and data retention rules, which are not tax rules, but which we need to take into account when we're thinking about what we retain and what we ditch.
Okay, brilliant. I think I'm really starting to get a good picture here. And I think maybe following from that, James, I'm wondering, one other thing that we talked about beforehand was that your work involves looking at what's gone wrong, projecting into the future, how it's not just compliance when there's a potential audit, but viewing it as a necessary step when setting up businesses or M&A or business integration. So could you tell me a little bit more about that aspect of your work?
Sure. We have a private joke with our colleagues, which is sometimes compliance and M&A is actually pre-controversy work because we kind of expect controversy. The actual compliance process can benefit a lot from what you learn in an actual controversy situation or an audit. And I think that's true also when we're doing M&A. You know, we go with what we've learned in the past about what potentially are the tripwires for the future in the target. So from a compliance perspective, when we've gone through an audit for an entity, we would look at, well, what went wrong with that? Where could we have found records better than we did? To Tim's point, what had we destroyed for very good reasons under legal or GDPR auspices, which we should have kept, or vice versa? What should we have destroyed and not been forced to give up because we had them? Those are really important lessons. Again, we've learned a lot in audits that you need to be thoughtful about when people leave your organization. Can you get them back to work with you on a future audit? So for example, would they go on the stand in a court case? Sometimes executives don't want to, so you put it into their employment contract that they need to, or that they'll get paid for that work. Because if you don't have that, they could quite legitimately say no. If it's not a criminal investigation, they could just say, well, sorry, that you're on your own now. That can hamper an audit. We've also learned a lot from audits in the past, just how far-reaching certain lines of inquiry can go for the revenue. And so we've been able to warm up our clients in advance. And I'm thinking particularly about certain countries such as France, who are extremely aggressive when it comes to PE, and they use PE, permanent establishment allegations, sometimes to bring threats to criminal prosecution for non-filing. The penalties are extremely severe for non-declaration of PE. So we've learned that the hard way. I guess I'd finally add that when you're looking at a target in an M&A scenario, and I've already mentioned the impact of Pillar 2 here, where the target may have certain reliefs which don't qualify under the refundable credits rules for Pillar 2, and there may be bits in the group that could end up pushing your ETR down below 15% once you're integrated. There's another point here, which is about culture. It's a rather soft point on an acquisition, but if you're going into an M&A scenario and you sense that the target is responding to diligence queries or negotiations in a way that suggests they don't have a particularly good handle on their compliance, we've learned again the hard way that you could be acquiring a target that's walking straight slap bang into an audit, pretty naked actually, without documentation, without personnel, without the right culture of responsiveness and compliance, and that could actually end up costing the client, our acquirer here, a lot of money because they've acquired an entity that might look okay on the surface, but once there's an audit, which is almost inevitable these days in some way in the future, they haven't got the right culture or documents in hand. So we've looked at that carefully and given feedback to our clients who are acquirers if we feel we're walking into a bit of a wasp's nest.
That's really brilliant. Thanks, James. Tim, I do have one other question for you. This is dealing sort of maybe a follow-up on the previous question regarding data accumulation and automation. So the role of entity software has become even more valuable in keeping track of corporate records. So when we spoke previously, you mentioned that you consider it a quote unquote tech asset. Do you think there's a strong business case for investing in this form of technology, not just for providing all the necessary data, but for when a tax expert is brought in?
Yeah, I do. I would say you need to, so you've got to get your processes right first before you invest in systems. I think that's important, or at least do it at the same time. And one of the things that regularly surprises me actually when I'm working with clients, that they might be in the middle of a dispute, or they might be sort of looking back at a transaction that happened 5-6 years ago, is how poor just data retention and the basics of where you keep stuff can be. So obviously there is a bit of a sort of rubbish in, rubbish out question here, but what entity software and technology does, even before you move into the more sort of live real-time data analytics type software, what that software does is it just enforces a kind of level of rigor in how records are kept, making sure that that basic information about the company is correct, that can then be used and can be turned around quickly when you do have inquiries from tax authorities, that the right stuff is kept, the right stuff is destroyed. So I think there's definitely a place for even the most basic of software, but definitely sort of further automation, so that you're overcoming some of the human risks and the sort of human nature related issues like staff turnover, which James referred to. I've had a couple of situations where you sort of have the worst of both worlds, where usually if you get a tax audit that is in relation to something that happened many years ago, and that can happen in a number of European countries, you either rely on there being really good records, or you rely on there being some person who's been there since the year dot who knows where all the skeletons are buried. And the trouble is, if you lose both, or if you didn't have the records, you didn't have any sort of technical way of retaining them properly, because they were just all in a sort of filing cabinet somewhere, and you've had staff turnover, you've got a new team, then it can be a bit of a nightmare. You're looking to piece together incomplete records. So in my view, you need both, but you can't rely on retaining people in quite the same way as you can rely on retaining technology and data.
No, that's actually really helpful. I think at this point, there's a question I wanted to ask both of you. There's sort of maybe a brief one, both of you talking about, which is everyone I've spoken to working in law, they've really talked about how COVID affected both the type and volume of work that they've been seeing. So could you both tell me a little bit more about that? Have you seen maybe a decrease in type of work or increase in some other type of work in the past few months? Have things remained fairly constant? So for example, some people permanently based in different countries, and how that's affected tax compliance work generally.
So I'll take that first then, Tim. By the way, I just realized my head's been moving and I inadvertently revealed the Network Rail sign. Just want to be clear, I don't work for Network Rail, and Legal 500 is no association with Network Rail. I just happen to be in that part of the building right now, so apologies. So there's huge amounts of new headaches thrown up by the pandemic. First of all, global mobility, as you said, Nathan. People were all over the world, and some of them liked it and stayed there, which has led to a transition, I think, away from employment in some cases and towards consulting, to try and de-link the individual from the mothership and try and argue that there isn't a PE there and there aren't payroll obligations, for example, or VAT. There's also a whole bunch of corporate and licensing issues associated, particularly when the legal function ends up for a corporate in a different jurisdiction. Secondly, burnout. I mean, it's boring to say burnout for the pandemic now, but we lost a lot of good in-house people and a lot of good, external advisors. It meant there were gaps in the compliance framework because people weren't around. They didn't want to work anymore. in the business, not our business. We managed to keep everyone, glad to say, but certainly clients lost people to either retirement, early retirement, or other clients and other industries. I think the global mobility issue will continue to be a key point, and over time, I expect there to be a very disparate workforce that's been almost the legacy of the pandemic, because people realize, certainly with broadband expansion and quality of life issues, actually it works very well. And I think it's down to the heads of tax to manage that. If they can't manage it, then they should be talking to HR or legal and say, look, this really isn't going to work, even as a consulting arrangement. But it's a very top of agenda topic within corporates now, because they want to keep the best people, and the best people don't always want to work in the city centres.
Yeah, and just to build exactly the same experience, I would say. So in terms of the global mobility or even national mobility, I think that's created issues which go beyond tax as well. I was talking to someone yesterday who had moved to the Cotswolds, got a London-based job, moved to the Cotswolds during COVID, is now having to come into London for meetings and find it a bit of a nightmare because it takes 2 hours to get there. But a lot of people have done that across border, and I think what it's done is it's crystallized and it's accelerated a trend which in theory was there already, but it's forced businesses to actually focus on what do we do when we've got a decentralized workforce. Can we really rely on the idea that the headquarters is in city X, and therefore that's where we're going to find people? And yesterday I had a question. It seemed like a pretty obvious answer, but it was interesting that it had come up, which was they've got people who are based in Switzerland, a couple of hundred people based in Switzerland. They're always concerned about supporting substance. And the question was, can these people work from home in Switzerland, or do they have to be in a physical office? And the answer was, it really doesn't matter. They might have some personal tax issues around which canton they're in, but it really doesn't matter from a corporate perspective. But you're getting those sorts of questions because everyone's alive to them. I think there's one other sort of human point for tax professionals, but for everyone, which is, I think when people were working predominantly online, I think it became increasingly difficult really to onboard very junior staff, fresh graduates, things like that, because one of the ways that you really get into understanding what the job entails is through socializing with people, from being in the office, from seeing how things work. And it was certainly something that we've grappled with. I'm kind of glad now that we've got people coming into the office more, because otherwise it can be a pretty lonely start to your career if you're doing it from your bedroom.
Especially in tax, which is a high technical load. I forgot to say something, Nathan. I just wanted to respond on one other thing. I don't know if it was just me, and Tim, maybe you can tell me if your experience was different, but at your organisation. But I don't know if it was just the pandemic and being at home and having nothing to do, but the number of HMRC audits went through the roof. The suddenly new discovered efficiency of not having to commute meant that we suddenly, I think, maybe it was unlinked, but we just got a flurry of compliance checks, audits, inquiries tumbled in. But on the other hand, the plus side was the revenue were very happy to process these compliance queries online. In other words, they could do virtual meetings. So I think it was swings and roundabouts. We noticed a massive increase in queries, but equally we managed to chock through the points a lot more efficiently than waiting to get 15 people in a room in Euston or in Edinburgh.
Yeah, exactly the same experience here. And actually one of the frustrations was that HMRC were by no means normal around the world. There are a number of, the ATO in Australia, otherwise fairly sophisticated tax authority, would not do things by video call for months and months at the beginning of COVID, which meant that everything just ground to a halt. So yeah, there was definitely there was some process efficiency, I think, which they enjoyed.
All right, brilliant. Really appreciate both of you telling me all about this. I think we've just about reached the halfway point, so I'm going to turn off the poll and should be able to see the results right now. Hopefully you can both see them. So looking at the second question, what are the biggest challenges in managing tax compliance, each of your organization's entities? Seems we got a 50-50 split between resources and regulatory knowledge across multiple jurisdictions. Could you both sort of just give me a brief gloss of your own thoughts when looking at that, maybe unrepresentative, but audience response?
Yeah, resources to me is a big challenge. I think with Pillar 2, everyone's going to be scrambling for tax professionals, allocation of capital from within the business to spend money on data collection, software, reporting. I think that's the biggest thing. I think that the audience is right to flag that one. I mean, we're competing for talent. The accounting firms are competing for talent, but the in-house teams definitely need more people and they need more money.
Yeah, and I think with resources and technology, it's not an either or, because you need good resources who understand how to use that technology as well. So I think a number of people probably, if they had the choice, would tick all three of those. You need capabilities, you need boots on the ground, and you need the software to support you.
Okay, wonderful. As we start moving into the second half, I'm going to share one other poll. This is just going to be for the very end. This is launched right now. This is on behalf of the sponsor for the event. Would you like to be contacted by Diligent? Just please answer yes or no. And I think now we're going to get into some of the very interesting part of the topic that we were going to discuss, primarily because I've titled it internally as Do's and Don'ts and All the Dirty Secrets Behind Tax Compliance. So I think start off maybe a general question is for both of you, is that one point that came up in our discussion is how there is on the one hand a sort of quote unquote tax fiction of how the business operate versus how it really is when you're in the thick of it. So maybe for both of you, can you tell me a little bit more of what it's like behind the scenes?
Can I reject, first of all, dirty secrets? I'm not allowed to talk about those as a lawyer.
Okay.
Whether they're dirty or not, certainly I can't talk about secrets. I think the interesting thing for me is just, and maybe I should also reject the word fiction. It's actually a tax plan or a tax strategy, not a tax fiction. But you're right to flag up that sometimes you have a tax plan which doesn't quite match up with reality, either in the documentation or the people in the right place or how they're accounting for things. I think sometimes accounting can trip us up when we think we know what we're doing from a tax perspective, but then the accountants have recorded loan as equity, or they've recorded a cost in a certain jurisdiction which we didn't even know we had people in. So there's a whole bunch of internal professional processes. I think there's a political angle as well. I've noticed that marrying up the tax plan to the strategy, to the actuality, depends a little bit on where the tax function sits. So if does the head of tax report to the CFO, the GC, the board directly, does he or she have a board presence? That very much radically alters how the tax strategy gets reflected in the corporate world. I think the other, I wouldn't call it a secret as such, but there's a realistic conversation now. We talked a little bit about planned non-compliance. We know there won't be full compliance. I think there's also a practical conversation to be had between heads of tax and boards and CFOs is, in reality, do we actually think the revenue will challenge a particular structure, even if it diverges slightly from the tax strategy? Because they just won't have, the revenue authorities won't have a lot to gain from auditing something, e.g. two parallel partnerships that aren't necessarily too linked at the top, but they may be still transfer priceable. It may be that sort of inquiry ends up with, again, swings and roundabouts, because the revenue find that there were greater costs but greater revenue, so they wouldn't bother auditing. That's actually a genuine conversation, or a cost plus audit where the revenue want to move to profit split and the business is in loss for the last 10 years, so maybe the revenue don't practically want to go there, or the dispute will end up in a MAP, a mutual agreement procedure with the US or with another European country. It's just almost no point. So you have these practical conversations with heads of tax that say, we don't really think this is going to be a practical issue. One other, I wouldn't again call it a dirty secret, but a tool which we've used a lot to address some of the compliance concerns is go to the revenue and ask for an advanced deal. Now, we're not talking about the dirty deals which got done in the 90s, which everyone still talks about with the revenue, where the revenue did things to make the money come in. But those were called dirty. I still thought that was good practice, but nevertheless, debate rages. We're not allowed to do that, quite rightly, in many view. But I would say now we use a different tool called the APA. So when you've got a cross-border situation, you're worried about filings, you're worried about compliance, get into the room with the revenue, not just the UK, but the other jurisdiction or jurisdictions that's involved, and see if you can hack out a 5-year plan and say, we're not sure exactly how to allocate. Can we all agree this is how we're going to do it? And let's not have an audit every year for the next 5 years or 10 years. That to me is an incredibly useful tool. Relies on the authorities having the people to be able to process it, of course. And it's not cheap, the APA, but it does save a lot of time down the road on difficult compliance questions.
Yeah, I agree with this, and it's a reflection actually of the way things have evolved in the last few years. For most tax authorities, in most cases, the biggest single source of extra revenue they can get is through transfer pricing adjustments. They might get lucky and find a huge VAT error that means that they've got tens of millions coming in, but usually the big deals are transfer pricing. And of course, the thing with transfer pricing is there's always a degree of subjectivity because it's based on qualitative information. It's based on the functions as they're carried out across the world. And the real world, we talk about the sort of the messy reality. The real world is usually a bit more nuanced than any kind of transfer pricing model, unless it's a complete global profit split, which could be a nightmare, can handle. You have certain fictions or simplifications within the world of transfer pricing, which companies have to adopt because otherwise things become too complicated. One of them is that you have routine entities which just do things that they're told to do and are therefore routine and should get something like a cost plus. And then you get entrepreneurial entities. In reality, often there's routine activity that happens in the entrepreneurial entity, and there's some entrepreneurial activity that happens in a routine entity. But if you try to reflect reality in too detailed a way, it becomes unsustainable. The other is that transfer pricing generally assumes that businesses don't change, or rather they operate in a stepwise manner. So you have a certain way of doing business, and COVID is a classic example of something that's paid to this, a certain way of doing business that operates for 10 years or 5 years or however long, and in that time nothing really changes. And then you get a restructuring, a business restructuring, and everything changes all at once in one big step, and you're operating in a new way, and that's when tax authorities like to go after exit charges, deemed disposals, things like that. In reality, of course, businesses evolve over time, and so often we've seen situations where there might have been a group which was headquartered in the UK, the decision making was all in the UK, but over time, because of the nature of its main markets, more and more of that has leaked across to the US. The question, or to somewhere else. The question then is, well, at what point do we switch? Do we flip the switch? And that can be quite difficult. And again, it's where, as James says, actually having the conversation up front with the tax authority, ideally on a bilateral or multilateral basis, so they can agree amongst themselves, when does the switch get flicked? What does that mean? What would happen at arm's length? It is really, really important.
Brilliant. I think I'm learning a little bit more about this, even though I don't have a law degree. But I think I'm able to follow so far. Maybe a follow-up question. This is something that the two of you were talking about in our conversation before this, was that when you're working in tax compliance, you have to operate under the assumption that when you're brought in, you're thinking about maybe three things. There is compliance, how much non-compliance is there, and how much in penalties will have to be paid. So I'd like to hear maybe briefly from both of you a little bit more about this framework or mindset when approaching tax compliance.
Well, I think, but the way I would state it is that the bare minimum compliance that needs to be done by any company is penalty protection. It's enough, because you should never have a tax strategy which involves getting caught out and paying penalties. So that's your sort of minimum level. There's then a degree to which you want to be sort of perfectly compliant. A lot of that is more about the records you maintain. James mentioned permanent establishment earlier. Get a classic example of where there are very few multinationals that can be 100% confident that they don't have some sort of theoretical PE somewhere in the world. So then it's about having the right governance structures, the right sort of principles of how you make decisions, and the sorts of things that you allow or you don't allow, that mean that you're keeping your risk to a reasonable level. And what that then means is when you come to get audited, you can show that you've demonstrated due care in the work that you've done, that you haven't been negligent, you haven't cut corners, and that's really important. So, penalty protection, absolute minimum, but then there's a choice to make as to exactly where you want to be on the spectrum beyond that.
100% agree. I think that's brilliantly put, Tim. I mean, I would summarize it's data, automation, and governance. I think that's what Tim has said, and I wholeheartedly endorse that. On the data side, if you want to avoid penalties, you need to show you did your best to find out about stuff. On the automation, again, it comes to penalties, but if you can show you've got a fairly automated way of getting information back to the head of tax and feeding it into the returns with some human overlay, again, you can show the revenue. You were trying your best, okay? It just the data wasn't coming to you, but not for a bad reason, but for good reasons. It just wasn't fitting with the model you've created. And finally, governance. You know, what is your means of checking issues? And I think once you've got all those three things down, so data collection and governance and a degree of automation to help you, you should have a fairly good conversation with the revenue.
Brilliant. Maybe following from that, James, I'm wondering, so you mentioned, I think earlier, that the way that you viewed tax compliance was through a lens I hadn't really thought about before, namely as tax compliance as pre-controversy. Can you tell me a little bit more about that way of looking at it?
Sure, and I don't mean by that we all wish bad things to happen. We don't, even though I'm a tax lawyer, I don't wish always to be in audit. But the fact is, we do expect audits. I mean, it's a pretty common thing these days. I don't know a single client that hasn't had an audit in the last 5 to 10 years on something. It could be very minor. So that's the first thing. We expect an audit. So that's why I always call it pre-controversy. Secondly, it's controversy, not litigation, right? So we don't actually want to end up in court a lot of the time. And funny enough, the revenue don't either, because it's costly. They have to make a business case for it, and they may end up with the wrong decision. So controversy is that arm wrestle with the revenue to get to the right answer, and hopefully have enough data to back that up. I would say, and this is a criticism directly, so people can take it as that, because I mean it that way. I do think the revenue, and it's why it's controversy, not anything softer than that. The revenue sometimes just start audits for fishing purposes. They cut a hole in the ice, they put their little line down into the ice, and they let their string wander around under the ice cover looking for fish, and that's painful and expensive. That's why I reiterate having the data, having the privilege protection to make these audits as quick as possible, because the revenue sometimes don't even know what they're asking for, and even worse, they're asking you to prove a negative sometimes. So they'll ask you to prove, well, why was the board silent on something when it was so important on the transfer pricing, to pick up what Tim said? You know, the board should have surely considered the arm's length nature of this transaction. Why didn't they? You can't go back sometimes 7 years and prove why the board didn't speak about something other than they had a very good head of tax who was taking care of business. So that is an incredibly painful process, and we expect it. So that's why whenever I look at compliance, I think, what happens if the revenue come and ask us about this particular strategy, or this particular subsidiary, or this particular hire, or this particular acquisition? How am I going to quickly get rid of any questions?
Oh, wonderful. Okay, so this one is going to be for both of you, but I think maybe starting off with Tim would be really helpful. Is sort of I'm interested in learning a little bit more from both of you about the corporate do's and don'ts and involved with tax compliance. You've both seen it all. I'm wondering if you could maybe construct a hypothetical worst possible case that you could have seen based on your years of experience, and tell me a little bit about what you think was going wrong at each stage and how that could have been prevented.
Sure. I mean, do's and don'ts are something which tax advisors are often asked for, and the most common areas where do's and don'ts are applied or asked for are around corporate residence. So where is your company actually resident? The avoidance of permanent establishments, and sometimes also equivalent rules in indirect tax, so avoiding a fixed establishment, or ensuring that a transaction is considered to be undertaken in a particular country for indirect tax purposes. Those do's and don'ts, I think, as a general rule, they work because essentially you're giving a list of things that a company can do, and then a list of things it mustn't do. They work if you have very specific rules that need to be complied with that don't get in the way with the way that people actually do business. And so I think corporate residence is usually manageable, because what you're saying there is you must have your board meetings in this country. You should have them a certain number of times per year. If there's someone who can't join, you must make sure that only happens on a one-off basis, and then also not the one who's making all the decisions in the board meeting. It should be face-to-face, etc., etc. And those are things that most companies can get comfortable with. when it gets to do's and don'ts that are around trying to force a business to do what just doesn't come naturally to it, and examples I would think of would be you've got your star salesperson and you're telling them that they're not allowed to negotiate with clients, or they're not allowed to quote prices to clients, when clearly that's what they do, that's what they get their bonus on, or you're saying that someone who's got family in a particular country should never work when they're in that country, when you know they've all got iPhones and they're going to be answering emails. They're not just going to ignore it. So I think back to your so my general point there would be, don't set do's and don'ts which are just invented to be broken. That's just a waste of time. The tax do's and don'ts need to reflect the kind of reality. In terms of the worst cases, I think it's where you have something which is a borderline sham. Essentially, you have a company has decided, or a business has decided, that they want to have a tax structure that relies on them doing things that just don't come naturally to them. Hey presto, they don't fly to those board meetings, or they don't make their decisions where they're supposed to be making them. They were never going to. They just thought that they could put some paperwork in place which says this is what we do, and that would be enough. And that it happens less than it used to happen, I have to say, but you still see quite regularly. You see instances of that.
I won't go to the absolute worst, Nathan, because that's criminal, and I have worked on criminal tax investigations, and that doesn't take a lot of imagination to think when things can go really wrong in that sense. Yeah, I think things like opinion shopping, when you find a whole paper trail where the head of tax has gone around looking for the right answer, that's pretty awful, especially in France. That can cause real headaches, and it's happened. I've worked for various companies which have, well, not various, I would say a couple of companies, one of which was listed, where they've been holding board meetings pretty much continuously in London because of the great hotels. And this was for all, a variety of foreign companies. And they had no idea that there was a central management control test in the UK. And when I told them about it, they promptly sacked me and hired another lawyer who told them exactly the same thing. And then they came back to me and we had to go off to the revenue they didn't want to, they shot the messenger and then realized they need the messenger to help them. So there are some pretty shocking things, but people nowadays are so sophisticated. The heads of tax are usually extremely well clued into the issues. I found that the education process is very quick. It's actually, they know as much as you. They're just looking for innovative solutions. So I don't think the really bad stuff from the 80s, 90s, 2000s really lingers. And the other thing that's changed is, of course, we don't see as many tax schemes anymore done by big corporates, and that's where I think, Tim, you and I play. We work for the larger side of the corporate world. They because of their culture, because of ethics, because of market perception, we just don't see as many tax aggressive schemes as we used to. So inevitably, some of the really bad behaviour, verging on sham, as Tim said, just doesn't arise anymore.
Well, I'm glad I was on mute for that very end of what you were saying. Had a good laugh. I think getting back on track. So one question I had for James, and Tim, you can follow up on this if you like, was that when we spoke earlier, James, you mentioned that in your experience, there's an inherent tension going on between lawyers and tax advisors, especially when it comes to the retention of data. So lawyers may not want data preserved, and this may be for perfectly reasonable reasons, GDPR, for example. While tax advisors, they want above all else to preserve things, and there's sort of an art form to weigh these things against each other. Can you tell me a little bit more about this point and how this might inform people who are watching right now about how to make that balancing act?
Sure, and by that I didn't mean to say there's a difference between tax lawyers and tax advisors who are lawyers. I mean, non-tax lawyers very often have very good reasons to want to destroy information. A, it's expensive, retaining it. B, there's a whole GDPR or equivalent custody issue. What do they do with the data? Do they have to notify people they have this data? And thirdly, it's just a cultural thing. There is sometimes a very big imperative in firms to not have a huge paper trail of stuff. Not from it's not a shady decision to do that. It's just that culturally they don't feel they need to keep lots of working papers or emails or whatever. They just want to keep the finished product, which all makes good sense. When it comes to tax inquiries, of course, that can be a good thing in that if you haven't got control of a document, you can't, or you don't own it. Sometimes your parent might have it, but you may not have it. Then that's actually a good answer to the question, please provide X, Y, Z. Sometimes it's a very bad answer if the reason why you don't have it is it's been deliberately destroyed. I think so. So to me, there is the clash whereby, as I say, non-tax lawyers might just do things which they think is right from their perspective. I think it's incumbent on tax teams in-house and tax advisors, whether they're lawyers or not, to just explain there are some nuances to that. So make sure you know why things are being destroyed. Can you defend the methodology as to why they were destroyed? Is there a good reason why they were destroyed? And make sure you do reach out into the organization and grab hold of things you do not think should be destroyed, because it may be very useful for you in future to get rid of an audit quickly. And that is, again, a resource allocation, because sometimes the tax function needs its own server. It needs to have advice as to how to keep that data safely. And that's an issue which I just wanted to flag. That's why I mentioned it before the call.
Well, if Tim doesn't have any follow-up points he'd like to raise, I do maybe have a follow-up question for you on one point. So there were a few other points that you brought up regarding what a tax expert should always keep in mind, namely not losing privilege and compliance, getting its arms around whatever documentation is available. So can you tell me a little bit more about this, maybe best practices, any other particular thoughts you may have?
Yeah, so the famous case, obviously, most people know in the UK, it's Three Rivers, but there's different privilege rules in different countries. In Germany, for example, there's only privilege when it comes to criminal tax investigations. So you have to be a little bit nuanced here. But I think generally speaking, the tax departments in-house are getting a bit more savvy on this, but be careful who you distribute legally protected advice to. It's got to be clearly the client acting on legal matters internally to decide or resolve legal matters to be able to benefit from the privilege. So I think controlling distribution is a real good thing. I also think that when tax strategy memos are being exchanged, or even pre-controversy discussions, so it's not quite clear there will be a litigation, which gives you a different litigation defense, which doesn't need lawyers to be privileged. If you're not quite there yet, you need to be making sure that certain drafts of memos aren't just marked up and sent back by non-lawyers. They have to be the subject of a separate email, in a separate email, referencing the document and not attaching the document, because if you've lost privilege in the comments, because it's just and it's attaching a document which came from the lawyers, and the actual attachment could have lost privilege as well. So we've been quite rigorous with some of our clients asking for comments from non-lawyers to make sure that those comments come back in a pretty clean email without the attachment. It's those little points which sound extremely annoying, and I am the person they accuse of being annoying, which is my job. But it does sometimes very much save a lot of angst later when we do get asked by the revenue for documents, and we can turn around and say, sorry, they're legally privileged. We'll see you in court.
I think maybe following up on that, talking about these little things, I do have a question for you, Tim. So one thing I'd like to ask you is sort of the difficulty that any tax lawyer is going to be experiencing dealing with corporates being compliant these days. And from both of your testimonies so far, it seems that it's gotten a lot better than how it used to be in previous years, but it still can be very difficult trying to convince corporates to take you very seriously. Do you have any particular sort of broad theories about why this is, and maybe ways that it could be improved?
I'm not sure it's difficult to convince corporates that they need to comply. I think the era of sort of deliberate non-compliant, I mean, it still exists to some extent, but there's much less than there was before, as James said. I think it's just that businesses find it difficult to comply, and this is back to the data point again, the complexity of compliance and the layers of different things that you need to comply with. When you think about, we talked about BEPS Pillar 2, and that's a whole new layer. There's been country by country reporting that large companies have had to do for a few years. Anyone who's operating in the US has got all sorts of stuff they need to think about, the BEAT rules, etc. We have corporate tax compliance, indirect tax compliance, payroll tax compliance. Often those are sort of heavily connected with each other, particularly when it comes to individuals moving around. You've got to think about payroll tax, immigration, corporate tax compliance. So it's just the burden of work that makes it very difficult to be perfectly compliant, and there's always some new requirement coming down the line. So I think our challenge is helping our clients to see through that mess, understand what they need to do, understand what data, what systems they need to have in order to support them, and understand who should be responsible for what as well. So what the governance structure around compliance looks like.
Brilliant. Given our time frame right now, we have maybe about 5 minutes left. So I'm going to move over to the Q&A if that's all right for both of you. Beforehand, I do want to thank both of you. It's been a real pleasure hearing you both speak. Looking at some of the audience questions we've had. So this one, I'm going to throw to Tim if that's all right. So there are a number of tax obligations under the UK's and Ireland's Finance Acts. How, in your experience, are companies performing?
How are companies performing? Well, I suppose so. We have basic tax compliance rules that have been in the UK Finance Acts and in our legislation for years and years. Requirements as to corporate residence, which I mentioned before, requirements in terms of the timings of filings, of claims, elections, etc. Of course, there's always new legislation that comes out. Governance-wise, there have been a couple of changes recently. One of the important ones was the SAO regime. So that's been around for a few years now, Senior Accounting Officer. What that essentially says is that there needs to be someone within a UK business who has the ultimate responsibility. If you think about the RACI, they are they're the accountable person, that the tax that is complied with and the books and records that support it are in place, and that there are processes to enable tax compliance. And that SAO is usually not an in-house tax person. It would usually be someone like the CFO. Those rules were introduced several years ago now. They were tightened up and given a bit more meat a few years ago. This was pre-pandemic. I think that has changed the environment in terms of what's required. The other thing for large businesses is what's called the BRR process, the business risk review. Now, this isn't legislation. This is HMRC practice. But what it essentially means is that HMRC will go through a review process with any of its large taxpayers that will establish how good their record keeping is, how likely they are to be compliant, what the likelihood of errors, the level of aggression in their tax planning, and so on. But I would say it's generally more about errors than it is about aggression in tax planning, and that will then determine how often they knock on the door and how aggressively they audit them. So that's something which has been in place for a few years, and I think has enabled HMRC to some extent to triage their audit activity.
Okay, brilliant. I know I'm going to try to speed things up a little bit to get through a few more, if that's all right. This one I think is appropriate for both of you. The question is, the role of accurate corporate structure data and transfer pricing is immensely important. Are there any major pitfalls before you're ever on the scene? I think that's referring to tax compliance lawyers that corporates usually fall for.
Yeah, so there is often non-description or wrong description in internal documents that sometimes produced. They don't reflect the transfer pricing strategy. I've also seen wrong accounting, as in what starts off as a financial book entry. So someone puts in the P&L adjustment for transfer pricing, shouldn't be just a statement adjustment for transfer pricing, because that ends up in the statutory account sometimes as a large adjustment for transfer pricing, which is arguably not deductible. It should be relating to a trading activity, or it should be an actual cost or payment for a service. It can't just be stated adjustment for transfer pricing, because the revenue can then argue it's not connected to the trading activity. So it is, unfortunately, the devil's in the detail there. We have to instill a culture with our clients and making sure that they appreciate that coming up with the corporate structure, the optimal corporate structure, or the optimal transfer pricing plan is reflected in all their internal documents that they generate and in the internal accounting. That's just a person power job. But those are the pitfalls I've seen. I can't really say we can always stamp that out. That's just down to attention to detail by the in-house teams. But that's from experience where I've seen people let down by the detail.
Yeah, one thing I'd add is, again, it's the timing point. Things change, and the frequency with which you update transfer pricing documentation, particularly. So there's two sides to that. So the economics. So if you had TP documentation that was based on an economic world pre-pandemic, you then go through the pandemic and what's arm's length changes. But I think more importantly, functional as well. So it's just inevitable. You will often get internal documentation that describes what happens, which is just has the terminology wrong. Sometimes you get a reorg and everyone has different names or different functional, or they're organized in a different way. Stuff gets out of date very quickly, and that can really confuse tax authorities. But on the other hand, you don't want to be spending the money, updating things every 6 months either. So there's always a balance to be made there as to how up to date you keep documentation.
Brilliant. We have one more question. And on this point, I want to thank everyone for being here today, as well as Diligent, because now we're going to begin the 17-hour-long discussion. This question is for you, James. How can you, in broad strokes, design your corporate structure for optimal tax efficiencies?
Either hire EY or hire Skadden.
Or KPMG.
Or KPMG.
Yeah.
Or any of the... No, I mean, that's an impossible job. Sorry, I forgot KPMG. Yeah, impossible job. I mean, I think you almost have to, if you want to say something, anything simple, just start with embracing high tax jurisdictions. Don't run away from them and just off into the distance to low tax jurisdictions. Actually, it can be your enemy, not your friend. High tax jurisdictions, onshore, substance, making things real can work really, really nicely. And it's just about getting the right planning within those high tax jurisdictions. If I was to say anything simplistic, it's that. And apologies, got that wrong, Tim.
No problem. Big Four. That's the key thing. Yeah, and just to add to that, I think make sure that any tax planning is tax planning is still a perfectly valid thing to do. Make sure it's sustainable. Make sure it's in line with reality, and it's something that doesn't have a life expectancy of a year or something. Make sure it's something that can stand the test of time.
Brilliant. On that point, I do again want to thank Diligent for helping to sponsor the webinar, as well as both of our speakers, Tim Sarson from KPMG and James Anderson from Skadden Arps. It's been a real pleasure listening to both of you speak today, and I think I've learned a little bit more about tax compliance. Wishing both of you all the best, and it's been a real pleasure listening to you both speak.
Thank you.